Timberlake filed a petition in court in New York State against the Sag Harbor police, asking them to not release the entire body cam footage from the day of his arrest to a reporter who had asked for it. The Sag Harbor police said, listen, we're not going to make a decision about whether this is private or whether this is public. Let's have a judge tell us. Welcome back to Allegedly Golden. If you are listening to this and not watching it, I am in my office on the library side with all of the books. I don't know, I'm just feeling books today. I've got my Diet Coke. Can you hear that? And a Masters cup. I don't remember whether this is from me going to the Masters or someone else going to the Masters, but a Masters insulated cup is always a good idea. So, welcome back, and thank you for coming back. You know, as I'm recording this, I am thinking about the next week, which is what I typically do on the weekends, as I think about what's coming up the next week. And the end of this week will start spring break for my child. And I don't know about the rest of you, but I have a very difficult relationship with spring break. And I don't know if this is something that we do in other countries. Someone let me know. In America, we typically get this break in the spring, but when in the spring really depends on what part of the country you are in, and particularly what the weather is in that part of the country. I feel like when I was growing up, spring break was right around Easter time, which is usually in April. And we would get time off for Easter, and then we would also get sort of like a full week off. I know that in many places it's still that way because school runs until mid to late June. But the school my son goes to ends in late May. So spring break is March, usually mid-March, right around the time it's going to be this year. And of course, it's wonderful to have time off. As a kid, of course, you want to have a break from school. Who wouldn't? But as a parent, what one can do during that time is actually a little bit difficult at the March point in the year. If you are fortunate enough, like me, that you can take some time off with your child, then you start thinking about vacation. A lot of people take spring break vacations. And it's become a challenge for us in the last couple of years because you have to go pretty far south in the United States in March for it to be warm enough to actually want to go to a beach. March can still be very cold. Certainly the water in the oceans can be very cold. Even southern Florida can be very cold. Even, the islands are usually, if you want to go out of the United States, are usually pretty good. But of course, that's further and more expensive. In recent years, people that we know have started going to Mexico for spring break because they can guarantee there'll be warm weather there. I'm just not sure that that is something that I want to do in March. Now, there's obviously a group of people for whom it is very easy because they ski. They snow ski. And so they use spring break as a time to go snow skiing. Now, snow skiing is the richest white people sport of all rich white people sports, more so than golf, more so than tennis. And so that is a very small population of people. I do not care for skiing. I am not very athletic. I've done it a couple of times. It makes me feel like I'm actively dying. That is not my jam. I don't mind going to a colder climate to be around snow. I rather like snow if I don't have to ski on it. And just that sort of ski culture of sitting in the lodge and drinking my red wine by the fire and reading my book. I'm not opposed to that. So there's a whole group of people who do that. But this year, we all kind of got together and we're talking about what do we want to do. Last year on spring break, we found what I thought was like the perfect spring break that I thought we would repeat for years, which is we went to Arizona and we went to spring training games for the league that's out there. And, when you stay in Phoenix, all of the stadiums for spring training are within an hour's drive. It's incredibly easy to go to multiple games a day, even. And we did that last year. And the boys did a lot of baseball games. I did some, but I also did a fair amount of like spa time and just like chilling by myself by the pool time. And I thought it was perfect. I'm like, great, we'll do this every year. I've got spring break covered. And so when I brought it up again this year, the boys are like, no, we don't want to do that this year. So I immediately got very frustrated and said, well, I'm not planning. I just can't. I usually love planning the family vacations, but when I get pushback that like, oh, that's not the absolute ideal thing that I want to do. It's like, well, if you have an ideal thing, then you've planned it. Mr. Nag is a bit of a homebody. Like he likes to travel, but he's not going to plan it unless it's for something he wants to do. Translation, sports, which is why I thought I had him at the spring training thing. And little Nag at 14 is kind of like, I'm very fortunate that he likes hanging out with us, that he doesn't mind going places with his parents, but he doesn't go a lot of the places that I want to go. So I was like, you know what? Why don't we go to London for spring break? Because the weather's pretty decent at that time of year. We're on the East Coast, so it's not that far. We'll have like 10 days to do it. I thought that would be easy. Mr. Nag has never been there. Little Nag has never been to Europe. I feel like that's a good entry point for Europe. And they both fought me and said no. So I just gave up. So we are going nowhere, which is fine. I don't need, and also the rates for everything go up during this time of year. Like the rates at beach resorts go way up, the rates at the ski resorts. So it's like crazy expensive because they know that everybody's trying to go. So I do not have a problem with staying home for spring break and just having like a little home time. The problem is that I will probably be able to take off more time from work than Mr. Nag, which means I will be in the house all day with little Nag, which means I'm the one who's going to get 75 times a day. Can I please order DoorDash? I'm bored. And I love my child, but it's pretty hard to fully relax when you are dealing with that. So maybe I need some rules. If anybody has any hot tips, I can't say call up one of your friends and go play with them because they're all going skiing or they're going to Mexico. So I don't know. I just have like a spring break stress, I suppose, if that's a thing. Look, if I get some time off of work, time off of work is not as good as it was because I'm doing this, because I use a lot of my free time to do this, which I'm doing voluntarily and I love, and I'm so glad I'm doing it. It's not sustainable like this. But, in terms of just like laying around in the bed watching bad TV, I could use a couple of days of that. I think we all could use a couple of days of that. Recently, I have been thrust back into the world of sports momming. We are not playing on a travel team this spring. For those of you who are sports moms or sports parents, that travel life is rough. We were on 2 teams last fall and Mr. Nag coached them both. It was a nightmare. I never saw him or my kid. And so in the spring, I was like, let's not do a travel team. Let's just do our school team. There's only 8 games or something like that. You can play with your friends. And, if you want to go and play with the travel team, it's sort of a continuation of the same team. And my husband's sort of a sometimes coach of that team. If you want to go and play with that team, sometimes you can if you just need to. Well, of course, the very first tournament He was like, I'm playing in the tournament. I have a feeling we're going to be playing in quite a few of these tournaments, even though we're technically not on this team. So I have been back to sports momming again. And as I've said before, I'm not that great at it. I'm great at cheering people. Like, I'm a great cheerleader. I am there for everybody. I am locked into the game. I am mad at whoever I need to be mad at, whatever ump I need to be mad at. Like, I'm very good about that. Like, if I have to pee, I will hold it until after my kid has their at bat. Like, I'm good in that way. I'm supportive in that way. But I sometimes have a hard time with all the other sports momming, because a lot of sports moms, all they want to talk about is their kid and how great they are or whatever. And I just am not interested in doing that. But I have to say, on the two teams that my kid is on now, one for school and one the travel, there are a couple of moms on each team that I have found that I'm like, I like these people. I can hang out with them. And I was thinking about like what the criteria are for that. Like, what is the criteria for a sports mom that I want to be sports mom friends with? And it's really two things, I think. The first is that you have to be realistic about your kid, right? Like, you have to be the kind of parent who's like, oh, my kid just fucked that up, right? Or like when my kid misses a ball, it's like, oh, come on, man. We practice that, right? You have to have humility about your own kid. I cannot enjoy watching a game with somebody who refuses to admit that their kid has ever done anything wrong. So you have to be realistic about your kid. And even to some degree, like, not shit on your kid, but like, if they fuck up, be like, oh, my kid totally fucked that up. Sorry, right? I need that. The second thing I need is I just need somebody who has really quick wit. I need somebody who will sit there with me and shit talk about the ump or the game or whatever. And we can just, I like a really dry humor. I truly think I was British in some other lifetime. I really like that kind of humor. And I need somebody who can just sit there and do that with me back and forth. And I have found good moms on both teams. So even though I have to sports mom more than I thought I was going to this spring, I'm happy that I found my people. And for those of you who are thinking, well, why don't you just talk to your husband? On one team, he sits in the dugout because he's sort of kind of one of the coaches. So I sit by myself. And on the other team, he is impossible to talk to because he is so intense about baseball. He has actually made a mom friend of his own who is also intense about baseball. And I'm like, you guys sit together because I don't want to be engaged in that. But I think I found a way to survive for the next couple of months. And I love watching my son play baseball because he loves it. I love, rooting for him, and baseball's a lovely sport and it's not violent usually. So I don't have to worry about that. But if I'm going to survive, I think I've finally, after all of these years, figured out what I need in a sports mom friend. And that's what I need. Right before this podcast, I was on a Zoom through Patreon with many of my, I think they're called patrons, actually. I just say Patreon people, but I think the actual word is supposed to be patrons because they pay. It's a patronage. We did a Zoom call for the first time because you can set that up through Patreon, even though I kind of screwed it up. And it was so nice to see a few people's faces that I'd never seen before. It was really nice to hear some people's voices that I'd never heard before. And honestly, like, just knowing that we were on at the same time. I know on lives, people are on at the same time, but you can't see them or hear them. You can just see the stuff that they type, and that it still feels kind of like it's just you talking at a screen. But it was really cool. I really enjoyed myself. I talked most of the time because I'm the yapper, but it was really nice. There were a couple of people who introduced themselves. I got to see a couple of dogs. It was awesome. And that just really felt like an intimate, conversation where I love getting to know people better because I talk at you a lot. And I want to talk with people sometimes too. So if that interests you, that's something we're going to keep on doing over on Patreon, which I believe is $5 a month. But also, I have it marked on my calendar. I believe later in March, you have to wait 3 months. I will have the ability to do annual memberships, which means I can offer you like a rate of, instead of, $5 a month, I can make it like $60 a year or something like that, which I plan to do as soon as I'm able to. So if that interests you, let me know. We talked about the Daryl Hannah op-ed in the New York Times and the First Amendment issues around celebrities and defamation and art and what people can and can't do. And do we think the law works the way that it is? And I find all those conversations fascinating. And I learn so much from my followers about, their own experiences and their own perspectives. And they are such rich conversations. And I just absolutely love it. Before I get into the legal stuff, I just want to say one thing, and that is in favor of a site I used to hate. And that site is eBay. eBay was always I always thought it was just trash. I didn't pay much attention to it. I knew that people bought computers on there and that kind of stuff. But I didn't realize how good it was for fashion until about 6 months ago. And I started going on there and looking for resale bags, because those of you who follow me know that a lot of my luxury bags I buy on resale for a lot of reasons. They're less expensive, they're sustainable, and oftentimes I like styles that aren't out right now. I don't want the bag that everybody has. I want the bag that I like. But I have been going down the rabbit hole over there, and there is some really good fashion on eBay. There are, some of it's secondhand, which is okay, especially for luxury designers. But that has become one of my favorite sites to just sort of screw around on when I have a free moment. I used to do that a lot on the RealReal, and I still do. But I've gotten to where at night I will be sitting there watching TV and think, I just need a light scroll while I'm watching TV, because this is, our brains have all gone to mush. And I find myself getting on eBay and looking at stuff that I would never pay full price for, but that I can get on eBay and get it verified. eBay has its own, eBay sponsor me. eBay has its own verification process, especially for luxury goods. But, it has long been an open secret on TikTok that you should buy luxury bags from Japan, because they have a really stringent, I guess, compliance or legal paradigm around the resale of luxury goods. They have to be proven to be authentic. And so they've already been authenticated. So whatever search I do now, if it's Gucci tote bag or whatever, I just add Japan to the end, because it's just show me stuff in Japan. But I found some Manolo Blahniks on there the other day. Anyway, if anybody has the Shoppies and, you just feel like you want to start looking stuff, and you can do a wish list where you follow stuff and see if the price drops. I have always wanted a Fendi baguette, but I want one of the sequin ones, and those ones are really expensive. They're $4,000 or $5,000, and I'm just not paying that for a purse. But if you put them on your wish list, eventually the sellers will start contacting you and saying, make an offer, or they'll make you an offer. And so it's sort of a fun game to play for anybody who needs a distraction from the world at large, which I think is kind of all of us. So it's now time for Civil Disorder, the segment where we discuss all of the active lawsuits and disputes that are going on by celebrities and high-profile folks out there in the world. This week, actually, quite a lot has gone on, and I've expanded the list of cases that I'm following because more things keep happening, and I think that's a good thing. I like the variety. We are still, as of this recording, waiting for Judge Lyman to enter his order on the dispositive motions in Lively versus Baldoni. I don't know if we'll be waiting for it when this pod drops or not. But as of right now, we are still waiting. That case is on hold. So I am not going to say anything about that particular case. But listen, guys, we got to prepare ourselves also for life after this case, right? Whether the judge enters an order dismissing it, or whether they settle, or whether there's a trial, we got to prepare ourselves. So let's just live in the future for a minute where there is no Lively Baldoni. Okay. First thing I want to talk about is Justin Timberlake, because what the fuck? So Justin, as we all know, got arrested last year. Last summer, it was June, I think, of 2025 in Sag Harbor for driving under the influence. He famously said to the cops, this is going to ruin the tour. And he was later bonded out. And I think they ended up dropping it or making a deal about it or something. The criminal charge itself was not a very big deal. But what happened this past week is that Timberlake filed a petition in court in New York State against the Sag Harbor police, asking them to not release the body cam footage, the entire body cam footage from the day of his arrest, to a reporter who had asked for it. So the reporter did essentially a Freedom of Information Act, public records kind of request. And Sag Harbor police are like, I don't know if we want to turn all this over. Timberlake's lawyer was saying like, hey, there's some stuff in there we don't think people should see. And I think what probably happened is that the Sag Harbor police said, listen, we're not going to make a decision about whether this is private or whether this is public. We're not going to make a decision amongst ourselves about, what the law says we should do here. Let's have a judge tell us. So Timberlake then petitioned the New York court and said, hey, I'd really like them to keep this stuff private, and asked a local judge to make a ruling on it. Now, a petition is a little bit different from a complaint because you are not seeking monetary damages. You're not saying, I have been wronged, I want them to pay me. With a petition, especially one like this, you are saying to the judge, we need a ruling on whether this particular exemption to the public records laws applies. We need a legal decision on whether this body cam footage fits under an exception to public disclosure. I, Justin Timberlake, think that it does. Sag Harbor says they're not sure. The reporter who asked for it says it doesn't. Please, judge, tell us what to do. The judge acted pretty quickly and issued what is called an order to show cause. And an order to show cause is pretty typical in a case like this where a petition has been filed that's just asking for a ruling. An order to show cause is a judge's way of saying, the person who filed this has made their arguments about what they think should happen. Now I'm asking the other people to tell me what they think should happen. So it is an order for Sag Harbor police to tell the judge why they should have to turn the information over, or if they dispute Justin Timberlake's argument that they should not turn the information over. It's like saying to Sag Harbor, like, what's your defense to this? So they have, I think, 45 days or something like that to let the judge know. And he said papers only, like he doesn't want to have a hearing. The judge said, file something and explain to me what you're arguing. I've seen Timberlake's arguments. He put it in his petition. He's uploaded affidavits. I know what his position is. He thinks that because this contains private information, it should not be disclosed publicly. What say you, Sag Harbor police? What's interesting is I don't think the Sag Harbor police really care. They're just the custodian of they're just the holders of the body cam footage. I don't know that they really have a strong opinion on whether they turn it over or not. Who does have a strong opinion is the reporter who asked for it, who tried to intervene in the case and say, hey, I'm the guy who asked for this and I would like to put myself in this case. And the judge said no. The judge said no because the rule that allows people to intervene is tied to hearing dates and things, and you are not on that same spectrum, so no, you can't come in here. So it will be interesting to see if the reporter files like some sort of weird amicus document or something, which probably isn't even allowed at this stage. But again, I think this is a fight between Justin Timberlake and the reporter, and Sag Harbor is just kind of stuck in the middle. But if I were an attorney for Sag Harbor, I think this is probably exactly what I would do, is I would say, listen, I don't give a rat's ass whether people see this stuff about Justin Timberlake or not. But if we turn it over and Timberlake thinks it shouldn't have been, then we get sued by Timberlake. If we don't turn it over and the reporter thinks it should have been, we get sued by the reporter. So let's let them hash it out. So who knows if they even put up a defense in this case? They may just say, whatever the court thinks is fine with us. And then the judge ordered that no one discloses it while they're waiting for Sag Harbor to respond. I think what Sag Harbor is likely to say is, we can redact this, we can edit out parts that show personal information. I don't know what kind of personal information they're talking about. And apparently this is like hours and hours of footage. But I think that's the middle ground, if there is one, is can't you just like edit out the parts that he doesn't want? Right? If they show his driver's license, or they show where he lives, or he's talking to Jessica on the phone about what they're going to have for dinner that night, maybe they cut that part out. I don't know. But that's going to be on the shelf for the next couple of weeks while Sag Harbor decides how it is going to defend that case, if at all. My guess would be that at least some of this footage is going to come out. I cannot see a world in which hours and hours of footage of a public arrest is all found to be private just because he's famous. I just don't see a judge doing that. The question is, how much will it be? And will it be any good? Like, what if it's all just filler bullshit? I don't know. I've seen a lot of people say that Timberlake must be hiding something, and I'm not sure that's true. Maybe he behaved badly. Maybe he had a Reese Witherspoon, don't you know who I am moment. Or maybe it's just embarrassing. I don't know. But a judge in New York State is going to work it out, and we're going to have to wait a couple of weeks to see what he does. On Karen Reed, who has given us the blessing of not one, but two civil cases that we can continue to watch. That high of that case, like it was such an exciting case, and it's like not ending, at least not yet. So there's two different cases that we have to pay attention to. First, the wrongful death case in which she is a defendant. She is being sued by the O'Keefe family. They are deep in discovery in that case, and the O'Keefe family's attorneys had they wanted to do an extraction of Karen's phone. So apparently her phone, like her personal cell phone, is still in the custody of the Canton police because it was evidence. And when it is released, the O'Keefe family was like, we want to get the phone and immediately extract it. Karen Reed's lawyer said no, because there's stuff on there that has nothing to do with this case and has nothing to do with you. So they fought about it enough that it had to go in front of a judge. And, I watched the hearing on YouTube. It's funny. They were like, we can't agree on this, so we got to get it in front of a judge. And they got to the courtroom and they got in front of a judge. And the very first thing the judge said is, go in that room over there and try to work it out. He made them try to work it out amongst themselves. And when a judge tells you, I need you guys to go try to work this out, you fucking work it out. Because what the judge is saying is, please don't make me decide this, because this pisses me off that I have to decide this and I don't want to. Judges like the parties to work things out. The system is, the civil system at least, is based on the idea that the parties can figure things out and only bring in front of the court the stuff that's absolutely impossible. Now we see cases like Lively versus Baldoni where no one can work anything out. But this judge, everyone was very excited. The courtroom was packed. Karen was there. She looks great, by the way. I think her parents were there with her. And then the judge just immediately was like, go over there and talk. So they were gone for, I don't know, 20 minutes or something. And they came back, and O'Keefe's attorney said, we have agreed to withdraw our formal motion about the phone, and Reed's attorneys have agreed that as soon as it is back in their custody, we will figure out a way for us to get what we want to get off of it. My suspicion is that they will figure out a way probably to do it like live in the same room. Like, you can extract the stuff you want, but there's going to be somebody sitting there watching you to make sure you don't also get, her healthcare records or whatever. So they kind of avoided having a big fight over it, I think, because the judge told them basically, I'm not putting up with this shit. Stop coming to me with this stuff. And it's the O'Keefe's lawyer who's doing it. I've said before, and I'll say again, I'm not very impressed with him. In the other case, the case in which Karen Reed is a plaintiff, where she is suing all of the people, her response to the motions to dismiss is due later this week. She asked for a short extension. The court granted it. So she is going to be responding to the motions to dismiss, both pro-speech motions and just regular failure to state a claim 12b6 motions, later this week by the McCabe's, the Alberts, Higgins, and Buchanan. Is it Buchanan? I believe so. Proctor answered. No, I think Buchanan answered. I can't remember. I don't have the chart in front of me. My bad. It's on every one of my social media channels. But her response, all of her responses are going to come back in one omnibus document, the same way that all of the defendants filed an omnibus motion to dismiss. She's going to file an omnibus response, which is like an extra long response talking about all of the issues. I think the reason why I'm so interested in this case is because civil rights cases are fascinating, but also, like lots of people, I genuinely want to know what happened. The confines of the criminal investigation, it's this unique issue. Maybe it's not that unique, but it's unique to me because I don't deal with it all that often, is you see somebody get charged with a crime. You look at all of the evidence. They're either guilty or not guilty. And when they're not guilty, that answers the question of whether they committed the crime under the law. But it doesn't always answer the question of what actually happened. And Karen Reed clearly truly believes that she was set up and that the McCabe's and the Alberts and Higgins had a part in John's death. And this is the case that she wants to use to get there. And so I'm imagining that her responses to the motions to dismiss are going to be, how can you let someone be charged with a crime, tried for that crime twice, and then be prohibited from figuring out whether she was set up, including by the police themselves? I think that's a compelling argument. I think it's an equally compelling argument to say, how can law enforcement do its job if it has to be worried about getting sued by everybody that doesn't get convicted, that thinks that they were set up? And do we want a society where private citizens are sued over things they say to the police? I think they're both compelling interests on both sides. But I'm going to be interested to see the legal arguments that she makes, because especially on the pro-speech, the Massachusetts pro-speech statute, it appears to set a pretty high bar for her. And I know they thought about this before they filed, but I'll be very interested to read what the law is on how she's going to get past that, because it looked like a pretty big obstacle to me when I read the motions. So hopefully we'll have that later on this week, and I will be sure to go through it. In the social media case, against Meta and Google by the young woman in California that I've been following and that you all have been following with me, we've reached kind of an important point of the case. The plaintiff has rested. So the plaintiff, the young woman who is suing these companies, claiming that she was addicted and that this caused her great mental harm, her case has rested. So her attorney has put on all of the witnesses and all of the evidence that they are going to put on. And now Meta and Google, which is YouTube, are putting on their case. It appears that the judge has created a really interesting rule for this trial, and I have never seen this before. I have seen judges get specific about, we're only going to go so long each day. We're only going to have so many breaks, that kind of thing. But this judge, who's a state court judge in California, before they started this trial, told the parties, listen, each side of this case, the plaintiff and the defendants, each of you has 40 hours total to put on your case, your affirmative case. So that doesn't include cross-examination of the other party's witnesses. But in terms of your witnesses, your direct testimony, your redirect testimony, your evidence, you get 40 hours. And when those 40 hours are up, you're done. And apparently, that is intended to make it more efficient. The judge said something to them like, when you go home at night and you're preparing for your direct examination for your next witness the next day, I want you to think hard. Have I asked this question already? In other words, don't be duplicative. It could end up being a good thing for both of them because it keeps you from going on and losing the jury because they're bored. So it might actually be helpful. But I think it's probably going to be harder for the defendants than it's going to be for the plaintiff because there's two of them. So we are now fully in the defendant's case, which means that Meta and Google are putting on their affirmative defense of the case. They are putting on now they have cross-examined every witness that the plaintiff has put up, as is their right, but they are now putting their own evidence into the record. And they're going to have some experts come on there and talk about what social media does and doesn't do. It appears that the plaintiffs might be waiting for their rebuttal because typically in civil cases, the plaintiff puts on their case, then the defendant puts on their case, and then the plaintiff gets to put on a rebuttal case, which means any evidence that directly rebuts or contradicts or goes to what the defendants put on in their case, the plaintiff gets to raise even if they didn't raise it before. So sometimes you save witnesses or you save evidence and arguments for your rebuttal case, which may be what they're doing. They're going to wait for the defendants to put on their addiction expert, and then the plaintiffs will put on their addiction expert. If you're the plaintiff, you get the last word, right? So it wouldn't be fair if you're the one who brought the case, you put your whole case on, then the defendants do something that you had no idea they were going to do, and then you don't have a chance to come back, right? So I think they may be holding some stuff back, including one of the whistleblowers. I think they may be holding back. But for now, we just have to watch what the defendants are going to put on. It appears that the first couple of witnesses that they put on were schoolmates of the plaintiff. Because remember that Meta and Google are arguing that if the plaintiff has severe mental distress, that is not because of her addiction to social media. That is because she was bullied at school. Because causation is everything in the civil law. You don't just have to prove that something bad happened, and you don't just have to prove that someone was damaged. You have to prove that one caused the other, which is what I'm going to talk about in legalese in the next segment. But we have a little bit of a peek into how the jury is going to be instructed in this case because some of the jury instructions were filed on the docket. Shocking to no one, they were hotly contested. Of course, there's some stuff that's standard, like, every jury gets instructed about circumstantial evidence versus direct evidence or whatever. But this is one of those cases where they were fighting for special instructions, meaning stuff that isn't usually used as a jury instruction. Most states and most courts have standard instructions for, this is how you instruct juries in a sexual harassment case, and this is how you instruct juries in a negligence case. And then you can argue for either modifications of those, or you can argue for special instructions, which are things that are specific to the case. And each side got like at least one special instruction that they wanted. The plaintiffs, so there was obviously a big conversation about age and whether that makes a difference, because the whole point of this case is that it's about minors. So the plaintiff got a special instruction that says there is a special duty owed to children. When you are dealing with children, you have a special duty in the way that you act, which is really big, right? You cannot look at this through the lens of how do these social media platforms affect adults. This is about how they affect children. Now, the defendants got a good special instruction, and this is one that big companies always try to get, which is you cannot consider the wealth of the parties when determining liability or damages. Don't find against us and make us pay her $1 bajillion just because you know our companies have tons and tons of money. It's an easy thing to say. It's a hard thing to do. But that was one that the defendants wanted and got. The case is going to trial on, or is in trial on, 2 claims, negligence and a failure to warn. And both of those hinge on this idea of there must be some legal duty. There must be some responsibility that these platforms have to the plaintiff. They have to prove that there was a legal responsibility, that they didn't do anything about it, and that she was harmed as a result. So the judge took the general instructions for those kinds of claims and modified them a little bit. I can, if anybody wants those, just DM me and I can send them to you. They're fascinating to read. But where that's all really going to come together is in the closing, right? But it gives you an indication as to how they are putting on their case. I mean, when you're trying to figure out how to try a case, you start with the jury instructions and you work backward, because you want your case to match the jury instructions perfectly, so that when the jury goes, first of all, you want to be able to argue to the jury instructions in your closing to say, you're going to read an instruction that says blah, blah, blah. Well, I just showed you blah, 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 and here's the evidence for that, right? And when they go back into the jury room, you want them to read the instructions and hear your voice in their head saying, well, this is the evidence for this, and this is the evidence for this. But it's oftentimes ignored leading up to it, because it's kind of a boring legal thing. So we will keep following it. I suspect that the Meta and Google case will go on for at least a couple of weeks. And then, of course, there will be a rebuttal case. So I think we're probably looking at least mid-April before we get a verdict in that one. And who knows how long the jury will deliberate for. The next case I want to talk about is a new one that somebody brought to my attention that I just think is such an indication of why I will never lack for content. A new case has been filed in California by 2 previous contestants of The Amazing Race, which I have to say is one of the reality shows I really like. I don't watch it anymore, but I used to watch it. Other than Survivor, it's the one that I feel like, I can handle the most. And I love to travel and I love seeing all the things that they do. But it is a typical reality show in that there's fake tension and fake, oh my God, there's not going to be enough time and all that kind of stuff. And Mr. Nag and I used to talk about, could we go on that show? Absolutely not. Absolutely not. I am a traveler who's like, let's go, let's go. I've got everything organized. When I say I'm ready to go, I am fucking ready. I'm standing at the door with the keys in my, let's go. When he says he's ready to go, we have 20 minutes left. He's still gathering up stuff and doing whatever. So no, we would not be good on that show. But it's a good show. But obviously, like any other reality show, it has an edit, right? They edit the way that people are perceived. And this couple, they're from season 37, The Towns, apostrophe S. I can never remember. Anyway, they're a married couple. And they were on season 37, and they are suing all of the producers of that show for defamation and false light, arising out of the edit that the show made of the husband on the show, saying that it was not an accurate portrayal of him. It was not an accurate edit of him. And when you read that at first blush, you're like, really? Like, give me a break. Like, who doesn't like who likes their edit, right? You can't just sue for defamation because of that. But there is a little bit more meat to it. I'm not sure it legally saves it, but there is a little bit more meat to it. So apparently, early on, this is what they allege. Early on, I think it was like in the first challenge, the husband like completely loses it. Like Mentee B falls apart, wants to leave. And he just got very emotional. Apparently, he's easily overwhelmed. And the production, he's like, I think I want to leave. I don't think I can handle this. And the producers convinced him, no, you should stay. Don't worry. It's going to be okay. We'll make sure you're all right. We'll make sure you're safe. Like, don't worry. You're in good hands. But that's not actually what happened, according to them. He did stay, and he continued to have emotional difficulties and meltdowns on the show. And in their minds, in the plaintiff's minds, this was edited to look as if he was angry and even potentially abusive. That his meltdowns were born of sort of an angry and potentially violent personality. And essentially, it sounds like they made him look like a real dick. I didn't watch that season. If this case goes on, I will. But so they say, he ended up looking terrible. And there's a couple of problems with that. The first is that after the show was over, we went and had him diagnosed, and turns out he's autistic. And we think that his being on the autism spectrum is the reason why he struggled so much with the show, because of all the stimuli and all that kind of stuff. And so when we told you that, you should have gone back and re-edited the show, which I don't know about that. But then at the same time, they said, well, we didn't know that and you didn't know that. But then they also say you did know that he was having some mental health issues, even though you didn't know what it was called. And you purposely edited our coverage to make him look angry without any context for it. That's kind of their big thing is. It's not just that you made him look angry and difficult and like maybe he was an abusive husband. Those guys that you see on reality shows and you're like, I'm glad I'm not married to that guy. He looks like an asshole. Their argument is it was without context, right? They dip in there in little pieces that, like, I think it was on the first challenge that they actually had finished the challenge first, but that another couple finished like right after them. But the Amazing Race like purposely fucked it up and made it look like the other couple finished first. And so they got first place. So they were pissed from the beginning. Right. They had in the very first episode, it was like we were robbed. Somebody else, looked like the winner. They got to come in first and we had a Mentee B. Right. So they were mad from the beginning. If you're watching this, my light is dying. So I'm going to look not as cute. Okay. Now, these are defamation and false light claims, both of which under California law require actual malice. Meaning, first of all, is the edit of someone on reality television even a statement of fact to begin with? Is a very interesting question. And then if it is, they knew or should have known that the things they were saying about him were false. My suspicion is that it creates interesting issues because we've been having this whole conversation about like the baby reindeer case and the case with Rachel DeLoach Williams on Inventing Anna. And then this week, the Daryl Hannah stuff on the Ryan Murphy show, and like how all of these different kinds of TV shows and movies, like what's the level, what's the standard of is it fact or is it not, and how much is it protected? And this is a new entry into that because it's reality television, right? Everybody knows that it's reality. My guess is that the defendants are going to file a 29,000 page document that these people signed when they signed up for the show that waives their right to all these claims. I mean, maybe it's just a lawyer thing, but I don't totally think so. every time my husband and I watch Survivor, we're like, do you know what the waiver must be like on this thing? It must be like, if I get bitten by a snake, if I starve to death, if somebody hits me over the head to get my immunity idol, like the waiver that you must have to sign to go on these shows, that basically if you die, you cannot sue, has got to be massive. Otherwise, they wouldn't let people on the show. So my guess is that these Amazing Race people signed some massive document that says they cannot do exactly what they are doing. And I'm guessing that it has in it a consent to whatever edit they think is appropriate. They've sort of tried to draft around that, but they drafted it themselves. And so they didn't do a great job. I don't think this case is going to last. I think it's probably going to get kicked. It's interesting, though, in reading it, I was like, I wonder if they have a better like disability claim. That like you knew that he was not just angry, but that he had like an organic disorder. They did say, this was interesting because I always wonder about this stuff with reality TV, that they were given a psychological evaluation before the show, because you have to like get cleared that I guess you're not a maniac, but that it wasn't a very deep psychological evaluation. And apparently, I mean, obviously, I don't think they need to test people for being on the spectrum, but apparently it didn't even go deep enough to recognize that, like, in the face of one single solitary challenge, this guy was going to completely lose his shit. So I don't know, like, maybe that's what they want. Maybe they want to, I mean, they claim this has hurt their reputation. Newsflash, I don't know who you guys were. I don't really think that's what's happening. But as a legal matter, it's an interesting thought. And I have long assumed that everyone on every show, whether it's The Real Housewives or Fear Factor where you eat bugs or whatever, that you have to sign something a mile long that says you can edit me however you want and I can't sue you for anything, even if I die. So we'll see if that's what happens here, but that is my deep, deep suspicion. So for legalese this week, let's talk about causation, because it is really the anchor of civil claims. And so many of you have told me over the course of the last year that that was one of the things that you really learned in following Lively Baldoni and other cases about how important causation is. And it really is everything. Most of all civil claims essentially have 4 parts. They can be different, right? There's some that are like, if you're claiming something is unconstitutional and you want to get an injunction, that's a different kind of claim. But most civil claims where people are filing a case asking for monetary compensation, they have essentially 4 elements. There is some kind of legal responsibility or duty, right? On the defendants, on whoever's getting sued. The defendants breached that duty. They either didn't do it, they did it wrong, they ignored it, they somehow did not fulfill whatever legal duty or responsibility they had. That the plaintiff, the person suing, was damaged, suffered some kind of injury. You have to have actual injury in a civil case. Something has happened to you. And that the breach caused the injury. And a lot of times in civil cases, there's a lot of legal argument to be had about, like, you know, what the legal responsibility is, right? Usually motions to dismiss a lot of times can be on that particular issue. It can be on the issue of like, well, the legal duty they're claiming I had, I didn't have. Or the kind of damage they say they suffered, they couldn't possibly have suffered, or it's not enough. Right? So the first element, and sometimes even the second element of how could I breach a legal responsibility I didn't have, or what I did wasn't bad enough to be a breach of that responsibility. Those are oftentimes more legally arguments. But causation is where the facts really come in. And causation is typically an issue of fact versus an issue of law, because you have to figure out the chain of events. So first you have to prove that someone had a legal responsibility to do or not do something. Like, let's just look at sexual harassment. You have a legal responsibility not to discriminate against people, right? You breach that duty by engaging in severe or pervasive unwelcome conduct of a sexual nature. Someone was damaged because of it. And then you have to prove that your conduct caused the damage. So that causation, if you don't have causation, you don't have the claim. But it is oftentimes very fact specific. And causation can be really, really difficult to prove, depending on the type of claim and depending on how clear it is. Causation is super easy in like an auto negligence case, or even a medical malpractice case where it's like the doctor cut off the wrong foot, now I don't have a foot, right? It's pretty easy to go from one to the other. You hit me with your car and now my back hurts. Well, even that there's causation questions, but physical injury is usually the easiest, right? So when you're the plaintiff, you want to just show this very clean chain of events. This, and then this, and then this, and that led to this. You want it very much to be sort of a syllogism of A plus B equals C. If you are the defendant, you are trying to break that chain, either by saying that this didn't cause, my activity, my conduct didn't cause the damage at all, or what's more common is it may have been a factor, but it wasn't the only factor. So for example, take the auto negligence claim where you say you hit me with your car and my back hurts, right? Well, yeah, the auto crash caused back pain, but a way that a defendant might try to muddy up the causation there is getting your medical records and finding out that you had another car crash the year before and you already had back pain. So how do we know how much of your back pain now was caused by your accident with me or your accident from a year ago? That's how you muddy up causation. In this social media case involving Meta and Google, causation is where they are really focusing most of their case. Yes, they are arguing that they as companies do not have a legal responsibility to keep minors safe on their platforms. They're arguing the first parts, the legal responsibility and the conduct, because you have to. But I think they know that that is harder for them to beat, right? I think that's a harder argument to say we have no responsibilities here whatsoever for companies with this kind of money. I think it's going to be pretty hard to get a jury to buy that. So what they have focused on is, okay, find that our platforms are problematic. Find that they're addictive. Find that there are things on there where we should be protecting kids better. But if she has suffered damage, that doesn't mean that we caused it. They are trying to break the causation link between their product and the plaintiff's mental health issues by saying other things caused her mental health issues, her parents' divorce, being bullied at school, something that is referred to as the pencil incident. They are trying to break the causation to either say our products didn't cause her injury at all, or the products alone did not cause that injury. Which brings us to the issue of how much causation do you need, right? Do you have to prove that something was the sole cause of the injury? Or do you just have to prove that it was one of the causes of the injury? And that differs depending on the type of claim that it is. Some claims require full causation, and some claims don't. In the social media case, they are using something called the substantial factor test, which says, and this is in their jury instructions, that in order to find in favor of the plaintiff, the jury has to find that the social media platform's failure to protect minors was a substantial factor in the plaintiff's mental health struggles. Doesn't have to be all of it. It just has to be a substantial factor, which means, of course, everything turns on the word substantial. which is, my guess is, what is going to be like 50% of both sides' closing arguments, is what does substantial mean? The only definition that's given in the jury instruction is it cannot be trivial or remote. So the jury, it's almost like an apportionment of fault, right? The jury has to go back there and say, okay, we believe this woman that she had severe mental difficulties and severe mental problems and still does, and eating disorders and all these other things after using these products. How much of that do we think is the products? How much of that do we think is her parents? How much of that do we think is her peers, right? How much of that do we attribute to the platforms versus everything else? And if they find that essentially she wouldn't be in this position had it not been for the platforms, then they're going to find in her favor. So that is a substantial factor causation standard. But there are cases in which it has to be the sole factor. You have to prove that A plus B equals C. And if you can break the chain, you can break the claim. And that is why cases that involve lost profits are so hard. If you are the plaintiff, they are so hard to prove. Because proving that you didn't get something, right? If it's like, well, I didn't make a profit because this person breached their contract or this person retaliated against me or whatever. All you have to do to break the causation chain there is to find other things that could have caused it. Well, maybe you have lost profits because your products were bad. Maybe your supplier ran out of the good material. Maybe people were on vacation because it was Europe in the middle of August. Maybe your TikToks wouldn't load because it was one of those, right? All you have to do to break the chain is to show that other things could have caused it. And in my opinion, this has always been the single solitary biggest problem for Blake Lively with her retaliation claims, is proving that something that Wayfarer did caused her reputation to take a negative turn, when there are literally hundreds of other factors that could have gone into that matter. And if those claims go to trial, then they would have to fight over the jury instructions there. Is this a substantial factor case? Which I think is what they put in their complaint. But when it comes to legal civil claims, causation is everything. You can't just prove that someone did something wrong. You have to show that they did something wrong. You have to show that you were injured by it in a way the law can compensate for. And you have to show that one caused the other. So I hope that that was helpful. This was a perfect amount of time for Allegedly Golden. We're just over an hour. I talked a little bit slower today because I tend to get excitable. And Mr. Nag was like, I like it when you talk in the voice you talk at in the beginning. So let's see if this is any better for anyone. Thank you for joining me. I really appreciate it. Feel free to ask me any questions or make any comments that you like. I love to get feedback from you guys. And I'll see you here next week because the drama never stops and someone has to make it make sense.